Hello friends, this is the second video of the series, and in this video we are going to do questions of CRPC. So now let's start with the first question. 1. Under which provision can the court issue a warrant of arrest against a person released on bail and require him to furnish sufficient sureties? So this is 2018 क्वेश्चन. जैसा कि हमने देखा था कि 2018 में मेमोरी बेस्ड क्वेश्चन बहुत ज़्यादा थे. तो इसमें सेक्शन 440 इज amount of bond shall be reasonable, and section 446 provides procedure when bond has been forfeited, and 441 provides that uh, uh, bond of accused and sureties. So the correct answer is section 443. 443, it provides that power court has power to order sufficient bail when the first one is insufficient. Question number 2. In reference to the trial of someone's cases by magistrate, which of the following statement is correct? So, option 1, the court shall frame charge after hearing the accused and prosecution. Since it is not mandatory to frame, it is not necessary to frame a charge. So, this option is incorrect. The court may discharge the accused after hearing the prosecution, and court may discharge the accused. So, when charge is not framed, it is also not mandatory. There is no requirement for the court to hear the accused, and particulars of the offense shall be stated to him. Yes, section 251 provides that substance of the accusation to be stated, and it does not provides that the accused must be heard before stating the particulars of the offense. So this is the correct option. Question number 3. Under which provision of law a body in corporate is required to appoint an authorized representative for the purpose of inquiry or trial before criminal court? Section 305 is the correct option. Which provision of the CRPC empowers a criminal court to recall and re-examine witnesses in a criminal case? So, option number 1 is 217. Section 217 provides whenever there is alteration in charge, witness has to be recalled. So this is also correct option. Section 311 permits the court to recalling witnesses if its evidence is necessary for the just decision of the case. So both the options are correct. Which provision of question number 5, which provision of CRPC provides protection against double jeopardy? So section 305, as we have already seen, it deals with the corporate bodies. Section 300 provides that no person can be tried again for the same offense on the same facts. This provision is also called uh, atrophies acquit or atrophies convict wala provision. Question 6. Under which provision of law the session court can make a reference to high court regarding the validity of any act, ordinance or regulation, determination of which is necessary for the disposal of the case? Section 395 of CRPC provides for the reference. Question number 7. A trial court in the state of Rajasthan delivers its judgment in English. Under which provision of law can accused seek a translated copy of the judgment in Hindi language? Section 364 provides that that if the judgment if the original copy of judgment is recorded in language other than the language of the court. So in Rajasthan, the official language of the state is Hindi. Hindi for the court, and if the judgment is recorded in his English, then in such case under section 364 the accused can request the copy, translated copy. Question number 8. Under which provision of law a sentence of death passed by the session court is subject to confirmation by high court? So option 3 is the correct option. Section 366 provides that the if the sentence of death is passed by court of session, it will not be executed unless it is confirmed by high court. Question 10. The trial court, while recording evidence in a case wherein the accused is in custody, records the evidence of witness without ensuring presence of the accused in the court. Which of the following statement would be correct? So, option one: the judgment passed by the trial court in such proceeding would be vitiated by the virtue of section 273. It is true that section 273 provides that the evidence against accused to be taken in his presence, but it also provides exception that unless otherwise provided. So, no, it is not covered by this, and also not by this. And the judgment passed by the trial court in such proceedings would be saved by the virtue of 317. So 317 provides few cases in which the accused is persistently disturbs the proceedings, or in the interest of justice, the presence of the accused is not required. So option 4 is the correct option. Question 11. Under which provision is the court acquitting the accused required to take a bond from him or for appearance in the higher court? So, section 437A provides for bail required to appear before next appellate court. Uh, but this section does not says that the court acquitting the accused. Maybe maybe the bond is only required when the person is acquitted, because if he is convicted, so he would be definitely sent to jail, I think. Question number 12. Which of the following documents cannot be admitted in evidence in a criminal trial without formal proof? Uh, Certified copies of public document. Yes, they cannot be admitted. A report issued by government scientist after chemical serological examination. These can be admitted. A report issued by government handwriting expert after comparison of disputed signature with admitted signatures. So it is doubtful whether I don't think it is admissible without formal proof. For a document which is admitted by opposite party. So by the virtue of 294 CRPC, this can be this is accepted from formal proof, and this is by the virtue of 293 CRPC. But option number 3, I don't think it is covered by section 293, because 293 clause G provides that any other government scientific expert specified by notification, but that does not specifically mention handwriting expert. So although the option 1 is correct option, but I don't think that option 3 is also correct. Question number 13. The Metropolitan Magistrate sentenced an accused of theft for 3 months imprisonment and fine of rupees 200. Accused can file an appeal against such judgment in. So if the sentence is 3 months and fine is rupees 200, there can be no appeal by the virtue of section 375 CRPC, which provides that no appeal in petty cases. No, sorry. Section 376 CRPC, which provides that no appeal in petty cases. So what are the petty cases in section 376? That is, if High Court punishes for 6 months and 1000 rupees fine, or the or the uh, court of session or any metropolitan magistrate punishes for court of session or metropolitan magistrate, if he is punished for 3 months plus 200 rupees, then it will not be appealable. And there are other cases also, like in if a magistrate of second class is punished with fine of rupees 100, then it is not appealable. In section 260, in a summary trial, if he is not, if the punishment is of rupees 200, then it is also not appealable. Now moving to next. Question number 14. Under which provision of CRPC can a party approach an executive magistrate and pray for dropping of proceeding initiated under 145? So section 145 provides when there is a dispute in a property with regard to ownership, and it leads to a breach of peace basically. So section 145, there is nothing to be discussed. Section 145 clause 145 clause 5 provides that the other party can approach that there is no such dispute exist. Question number 15. Under which provision of law can the court award compensation to a person groundlessly arrested? So if a person is groundlessly arrested, he can be granted compensation under 358 of rupees 1000. And if there are more than one person who are arrested, then 1000 rupees each. Question 16. The judgment passed by Honorable Supreme Court in Hardeep Singh. Hardeep Singh is famous for Section 319. Question number 17. Order made under Section 144 of CRPC shall not remain in force for more than what dash 2 months. 2 months from the making thereof. Although it can be remained for in force 2 months plus 6 months in case the state government desires to extend it, but initially it can be only remain for period of 2 months. Question number 18. Which provision of the Code of Criminal Procedure 1973 deals with identification of person arrested? That is 54A, inserted by 2005 amendment. Question 19. Which of the following statement in respect of section 320 of CRPC is not correct? Not correct. So in the composition of an offense, option number 1 is the composition of an offense before charge shall have the effect of discharge of the accused. So the composition under section 320 has the effect of acquittal and not the discharge. So this option is incorrect. No offense shall be compounded if the accused by, yeah, this is also correct. When appeal is pending, the composition for the offense shall be allowed without delay. This is also correct, and this is also correct. So option 1 is incorrect. Under the provision of section 105 of CRPC, identifying includes, ये क्वेश्चन तो आई थिंक दोबारा कभी नहीं आएगा और ये अनएक्सपेक्टेड क्वेश्चन था. 105 इसमें basically identify includes in the definition establishment of proof that property was derived from the commission of offense. Question 21. Evidence in the proceeding of section 125 of Code of Criminal Procedure shall be recorded in the manner of summons cases. Question 22. Under the Code of Criminal Procedure, security for good behavior from the person disseminating seditious matters can be demanded by, for the seditious matter can be demanded by executive magistrate. Question number 23. Under section 41 of CRPC, whom amongst the following police cannot arrest without warrant? Option 1. Who commits in presence of police a non-cognizable offense. So in presence of police, if non-cognizable offense is committed, police cannot arrest without warrant. Okay. Who commits in presence police officer a cognizable offense, he can be arrested. Who commits in presence magistrate a non-cognizable offense, even then he can be arrested. So option 1 is correct option. Question 24. Section 436A of CRPC provides for the grant of bail to an accused pending trial if, option A, he has undergone detention of 1/4 period. No. Option B, 1/3. No. Option C, he has undergone 1/2. Yes, this is the correct option. Question 26. Which of the following is correct statement as per correct statement of law as per section 82 and 83 of CRPC? The court may order the court may order attachment of property belonging to an accused before declaring him proclaimed offender under section 82. No, it cannot be so. So it is incorrect. The court may order attachment of property of a person after publication of a written proclamation under section 82, require him to appear before it. Is the correct option. The court may order attachment of property for person regardless of whether or not he has declared a proclaimed offender. So the correct option is option B. Question 27. Which of the following irregularities of a magistrate not empowered by law to do so vitiates the proceedings? So, which of the act will vitiate the proceeding if he is not empowered to hold inquest under 176? No. To make over a case under subsection 2 of 192? No. To take cognizance of offense under clause C of 190? Yes. Question number 28. Which of the following irregularities of magistrate not empowered by law to do so does not vitiate the proceeding? So, option A, calling off record to exercise powers of revision under 397. No, this would vitiate. Taking B, taking cognizance of an offense under clause A or clause B of subsection 190. So this does not vitiate the proceeding. There is distinction between the clause A, B, and on the other hand, clause C of section 190, because in A and B, the cognizance is taken on police, either on police report or on the complaint. But in clause C, it vitiates the proceeding because the magistrate takes the cognizance in not only on any other manner, but it includes also his personal knowledge. So if he is taking cognizance on his personal knowledge, and he is not empowered by law in that sense, so it will vitiate the proceedings. And decision of an appeal, this is also incorrect. Revision under clause under 460. This is also incorrect. So option B is correct. Question 29. Which of the following offenses is cognizable, non-bailable, and non-compoundable? So the most serious offense in the options is section 307, attempt to murder. So question 30. Statement of an accused can be recorded on oath. Can be recorded on oath. So option A is not correct statement of law. No, this is not the option. Under section 315 of CRPC, 315, yes, yeah, he can be recorded on his statement can be recorded on oath under 315, because when he himself seeks to produce himself as a witness, so he should be given oath, administered oath. See, specifically it is mentioned in 313 that no oath is required. 391 is something else, that is additional evidence. This is also not important. So option B is the correct option. So until now we have done 30 questions, and we will do remaining more questions. I think around 20 or 25 questions are left. मैंने इस वीडियो में काफ़ी जल्दी जल्दी बताया है. एक्चुअली मेरा ऑब्जेक्टिव इज टू गिव यू आइडिया व्हाट टाइप ऑफ क्वेश्चंस आर बीइंग आस्क्ड इन द प्रीवियस एग्जाम्स, एंड विदाउट वेस्टिंग मच टाइम, बिकॉज प्रिपरेशन तो आप लोगों को खुद ही करनी है, बट द टाइप ऑफ क्वेश्चन आप इसमें से देख सकते हो. एंड द बेस्ट वे टू utilize these videos is to watch a specific topic before preparing for the that topic, not to watch whole the playlist at once. Thank you.